Hello and welcome to Business Today Television. I'm Siddharth Zarabi and you're watching Easynomics. On the show today, we discuss the Digital Personal Data Protection Bill, which has been tabled in the lower house of Parliament. And this is a proposal that hopefully will bring India closer to having the first kind of legislation that addresses both the need for privacy of all Indians, and it also attempts to establish a framework for the usage of data by both private or government entities. But as you can understand, such a law is easier said than actually drafted and passed. And joining me now to discuss some of the day two questions that arise from this version of the bill, remember it's been 6 years in the making, is Manish Sehgal. He is partner risk advisory at Deloitte India. We are also joined by Shahna Chatterjee, a partner at Shardul Amarchand Mangaldas and Company. Thank you very much for joining in. Shahna, I want to come to the first question really, which pertains to almost every single smartphone user in India, which is apps. We live in an app economy. And before we discuss individual rights, I want you to come to the point about what really will be the impact of these provisions if passed into law with regard to the entire app economy, both for the operators themselves and for the individuals who interface with these apps several times a day.
Sure. Thank you for that, Siddharth. And I think you're absolutely right that, while this is a horizontally applicable law, which means that it will really apply to anyone who processes or deals with personal data, there will be very specific impact on specific ecosystems and on specific sectors. And I think the app ecosystem, like you rightly described, is going to be one of those sectors. Now, I think from what we have seen and from the work that we have done in this space, a lot of these platforms are already subject to a fair number of content regulation, data governance norms already, whether from India or by virtue of them being, globally present. So I think what the incremental impact that is going to get created is really around very specific issues, for example, around how these platforms are going to now enable data subject rights. As you know, that this law is now for the first time creating a very comprehensive set of rights for data principals in India. And enabling those rights is now going to be an area of focus for a lot of the app economy. The other thing that I think some of the platforms are going to want to think about how to deal with the manner in which they are currently processing children's data, for example, right? So a lot of gaming apps, edtech apps that usually and routinely process children's data will also now need to stop and rethink about how that processing is happening. What are some of the restrictions that the law is now putting in place, whether they're eligible for some of the exemptions that the law has also provided for, and how that is going to impact their operations. So, while they will have to, in any event, think about consent management, retention policies, etc., I think the specific impact we might see around these two or three broader issues.
Okay, there are more questions that we have collated and they're coming up on the screen. I'll request my producers to bring up those questions, and viewers, if you have questions, do also send them to us and we'll try and get them answered, if not today, in subsequent discussions. So the two questions on the screen: are any data fiduciaries exempt, and what does it mean for digital security? Manish, let me come to you on that point about data fiduciaries and the exemptions that seem to have been provided.
Right. Thank you so much, Siddharth, for having me here. Well, exemptions are definitely called out, and every act will have provisions for exemptions, maybe in the larger interest of economy, national security, sovereignty. So yes, there are exemptions. Now, those may relate to the reason for which the data is being processed or accessed. I think that's where the merit lies. Uh, Most importantly, I think there is a lot of focus on what is exempted and why there are those exemptions. But to me, there is a larger equation that we have to solve in the room. What about the areas which are not exempt? Shahana, my co-speaker, very beautifully called out that there are requirements, whether it is an app service provider, merchants, or users, they will have to adhere and comply with. Are we able to even take control of those requirements? Are we even having the right infrastructure, technology, processes to address the requirements, let's say, of a data subject who is keen to know what are you doing with the data? Are you able to even process it out? So yes, exemptions are there. They will be definitely called out, and based upon what we have noticed in the international parlance, exemptions may be dynamic in nature in terms of getting more modified as we start to gain more traction and understand what is goes about. So exemptions are there, and they will continue to be.
Manish, is there any example that you can share globally of a similar set of exemptions that are provided for or are being discussed? Because the question is that the government of India, according to me, minus social media, holds the largest amount of data of the average Indian, and the same person is footprinted multiple times in various different government, union government, state government, even local panchayat level databases that exist.
Right. So no, there are examples. I'll give you an example per se. Let's say that there is a outbreak of a disease. Let's say there is a medicine which is out and needs to be recalled. Now, for those circumstances, the provisions of the bill of this kind may not be held back to first of all call a user whether we can use our data to understand what is required, because the interest is larger. It is not to hit anybody's personal privacy economy, but it is all about giving the interest of the nation. So if there are outbreaks of that kind, if there are reasons that may evade the national security, there have been instances in outside the world, outside India as well, where such exemptions have been called out, and those are required to make it very practically used in those circumstances. If there is something going wrong, and my data is required to do something in the interest of the nation, I need not be called to take permission, Manish, can we use your data or not? Because the interest is larger, and those exemptions are very, very required in those
Okay.
circumstances.
Okay, fair point. Let me go back to Shahana. On the screen, we
Yes.
just saw uh, a question that came up on cross-border data. Explain that to the layman, especially because a lot of people interact with the digital economy not knowing who really, at least in the corporate entity terms, is collecting that data and where that data is going to ultimately reside and at what end uses that entity may choose to put that data through.
Absolutely. So let me, before I explain the provision as it exists in the current bill, let me just do a quick recap of how this provision has evolved. And Siddharth, like you said at the beginning of the show, we've been working. India has been working on this framework for 5 or 6 years now, and there have been a few iterations of the bill that have also been made public. And I think the manner in which cross-border data flows has been handled in each of those iterations is very indicative of the way that the policymakers and the lawmakers in India have thought about and understood cross-border data flows. So we are coming from a point where there were, fairly hard localization requirements for certain categories of personal data. Now, that basically meant that for certain categories of personal data, sensitive personal data, that data had to reside in India. We then went on to a position where there was, the position was that, listen, you can do cross border data flows, you can share data, personal data, outside of the boundaries of India, to countries or to jurisdictions that the government notifies. And we were referring to this as the whitelist approach. So essentially, the government had the ability, based on certain considerations, to identify certain countries and certain jurisdictions. And it was only to those notified list of countries or jurisdictions that we could do cross border data flows with, or we could send data to. We have now arrived at a position of a blacklist approach, which essentially means that the default position is that you can do cross-border data flows. You can freely transfer and share data across the boundaries and borders of India, unless the government has identified a particular country or jurisdiction on the blacklist. So, unless the government says by notification that here is a country that you cannot share data, you cannot transfer data to, um, data fiduciaries in India, businesses, entities in India can freely share data across the boundaries of India. Now, why is this important? I think, like you said, one of the considerations, of course, is that where is my data going? Is it going to jurisdictions where that data might be at risk, whether from state actors or other bad actors? How do I ensure adequate protection once my data is flowing to those jurisdictions? And I think one of the ways in which the law has addressed that challenge is by saying that we will make the data fiduciaries, the entities who are actually taking a call or who are responsible for sharing that data across India's borders, responsible for the safety of that data. And I think that that's a reasonable measure to take, because ultimately they are the entity who is most adequately, who's best placed to determine what jurisdictions should this data go to. It is in their interest to share data across borders to jurisdictions or to countries that are safe and enabling. So I think we, at least with the cross-border data flow provision, I think we have hit a very good middle ground. And it's been a long journey to get to this position, but I think this is a fairly reasonable and a good logical position.
Okay. Manish, I come back to you on the impact that this will have on the digitalization of the health sector. The health sector has been in focus ever since COVID. One of the world's largest databases has been created, which is the CoWIN platform. Uh, what is the impact, if any, that these provisions are likely to have?
Uh, I would say, be it health sector or any sector, the impact is going to be significant. And that's the reason I see this as a transformational move. Health makes it further more sensitive purely because of the information about the patients, about the research, about the disease that it will have. The basics of the bill still calls out the same, that the data should be used only for the legitimate purposes on a lawful basis. There should not be circumstances, be it in a health sector or anywhere else, where the data collected is being used not for the purposes defined. That is going to be very, very important. Second, let's say if there are research to be performed, let's say if there are clinical trials to be performed, those will have to be performed in a manner that the data which is used either with the right authentication, consent of the individual, or in a manner which is anonymized. That means anonymization, by doing anonymization, the data may still remain, but the identifiers to identify an individual may be taken away. For example, let's say there's a data of Manish Sehgal, and there would be attributes about Manish Sehgal is as an individual. If we take out the details like name, person, the data will still continue to be there. It may still provide the required value for the research, but the necessity of identifying an individual may be gone away. So the implications will be high. There will have to be process and technology changes that will have to be adopted. One significant interest or value will be there, that there will be further security that will be provided by ensuring the data is not being misused. It is limited only for the people who require it. Let's say hospitals, everybody need not be required to know the access of the data of the individual, the patient who is coming in. It will be limited only to the people who are supposed to do. And I'm sure many such improvements will come along as as the enforcement starts to get in and healthcare enterprises starts to start adapting those practices.
Okay. Shahana, and I'll come back to you on that point as well, Manish, but Shahana, to you, explain the whole penalty architecture that is being proposed. And the reason this is important, viewers, is that so far, if there was a data breach, one, you as a user really don't know officially whether that data breach has occurred. Various reports come, people say that digital identities are floating around on the dark web. Sometimes you might receive any evidence that shows that your data has been used for example, a loan application.
Yeah.
This bill proposes to impose fines.
Yes.
Shahana, explain that to the average viewer. What does it mean and how will it really work?
Sure. So there are a couple of issues over here, not just what the penalty framework will look like, but one to start with is that what is a data fiduciary's obligation. So a data fiduciary is anyone who takes your data, who processes your data, would be a data fiduciary. What is their obligation in terms of ensuring that that data is processed safely and securely to begin with, right? So this law, for example, makes that very clear that it is the data fiduciary, it is their primary obligation to make sure whatever personal data is being processed safely and securely. If there are any third parties that they're working with, they will have to ensure the same level of compliance, data subject rights in terms of ensuring that the data, data principal rights, I beg your pardon, in terms of ensuring that a data principal is able to ask and find out where my data is, who has access to my data, what is my data being processed for. All of these things will have to be enabled and taken care of by the data fiduciary. Now, in the instance of a personal data breach, and the reason I'm emphasizing that is because we already have existing laws for cybersecurity incidents or other types of breaches. But for personal data breaches specifically, there is now a whole new framework around what the obligations will be for a data fiduciary and what are the sort of remedies that a data principal can expect. So if I as a data principal today find that there is some information available with a third party to whom I have not given my consent, I have the right to find out how they got that data. I have the right to file complaints with data fiduciaries. I have the ability to go to the data protection board and file complaints. But in addition to that, data fiduciaries also will have the obligation to inform me as a data principal if there has been a personal data breach. So the obligations around personal data breaches is becoming a lot more complex and a lot more nuanced. And it's not just limited to the instance of the breach, it actually begins way before that when the processing of the personal data itself begins. So I think, of course, this is a positive development. I think there will, like Manish said, a lot of the proof will be in how some of these provisions are implemented, how clarity is brought around some of these provisions. But in terms of setting up what the legal regulatory requirements are, it's a fairly nuanced and a well thought out framework.
Fairly nuanced and well thought out. Manish, what impact will it have on businesses? Will the cost of doing business go up? Will this impact businesses negatively? Or is it something that in the long run will actually be good for business? If a business doesn't lose data, it will always retain customer trust, for example.
So everyone has two sides, and the one that you mentioned was the latter is where I would be inclined towards. If I'm a user and if I get a confidence that the enterprise data fiduciary, significant data fiduciary with whom I am sharing my data, and if they're able to take care of data, they don't misuse it, they don't compromise on the security, they will have me as a more trustworthy customer. My loyalty to that enterprise increases. So there could be initial days when a lot of transformational change will be required for enterprises to start adopting, understanding what this law means, how to really start implementing it, what are the use cases that may apply to me in my industry. So definitely there will be an effort, but in the long run, this is must. Purely because of the points that you mentioned, the trust. It is very, very difficult to have a trustworthy, loyal customers, clients, enterprises, and this is the means to it. Uh, Another important element is that I, as an individual, how much aware I am about this law. For last 2 days, I think most of the discussions I have been part of are very focused on the enterprise, the data fiduciary, because that is where the lot of change will have to undergo. But it is very equally important that people like us, whose data is right now being, we are given authority to start governing that. Are we really made aware about what rights I will have? How to exercise them? I think there has to be a tremendous effort there as well, because that's how I will be able to complement what enterprises are trying to do, the classic platform that government is trying to provide to me, and I will have a way for me to control my own data. So I think overall, in a long run, I see this as a very, very optimistic and a positive move to ensure that trustworthy and loyal customers continue to stay with you.
Okay. Shahana, the last question on the show to you, and I think we briefly perhaps touched upon it, but what is the data that is excluded from the provision of the bill? Uh, does it only pertain to online personal data, and what about offline personal data that may not be part of a sort of ongoing transaction?
So Siddharth, I think this bill certainly goes beyond the question of online and offline. I think it is a question. It has a much broader scope. And what this bill is doing is talking about personal data as a whole, but specifically governing digitized personal data. And it's very interesting that they focused on digitized personal data versus online or offline data, which is how you and I would typically understand how data is today consumed and processed, right?
Can I
But
interrupt you there? So, for example,
yes,
if I apply for a driving license online,
yes,
that will be called digital
yes,
data. But
yes,
suppose I submit a physical application somewhere,
yeah.
will that be offline personal data? I'm trying to understand this concept myself as well.
Sure, sure. So, I think in that example, when you're filling out an online form, absolutely no question that is digital personal data, this law will be applicable, right? Subject to the exemptions. In a situation where I am physically putting pen to paper to provide personal data, the question then becomes is that at any point of that data journey, does that data become digitized? So I may fill out a physical form, but I may have a assistant or a business correspondent who ultimately digitizes that data for further processing. Now, that processing may not even happen online in the typical sense that you and I understand it. It might happen on software, it might happen on digital devices. And in that case as well, the act will apply because that is also considered part of what is digital personal data, or that is part of the journey that will be subject to this act. So the question is not so much about online or offline data. The question is really more about, is that data digital data or not? And if it is, then the act becomes applicable.
Well, I should have asked you this question at the very top of the show. Maybe we would have gone in a completely different direction, Shahana, because, but I'm glad I did ask you this at the end, because it perhaps sets the opportunity and the stage for another round of discussions with both of you. Once the parliamentary debate process gets underway, so viewers, we are not going to sort of stop here. We've been trying to unpack this legislation, like I said, 6 years, multiple drafts, except the people who have perhaps drafted it. Most people do not have 100% understanding of the fine print. We'll see how the legislative process goes and pick on other points to understand this very seminal proposal in law, that is to protect our digital avatars. Shahana, Manish, thank you very much for your time with us today. With that, it's a wrap on this episode of Easynomics, viewers. We'll be back with more. Till then, goodbye.
Months after being slam dunked by Hindenburg allegations, the Adani Group is returning to mergers and acquisitions with a vengeance. Early Thursday morning,